Good morning, everyone. Welcome to this oral arguments. I want to ask Mr. Stark to please read the docket.
Thank you, Mr. Chairman. Mr. Chairman, other commissioners, we're here for the proceeding to hear oral arguments in matters incorporated in dockets 2019-176-E, 2019-184-E, 2019-185-E, 2019-186-E. The oral arguments have been scheduled for today, July 17th at 10 a.m. in the offices of the Commission at 101 Executive Center Drive, Columbia, South Carolina 29210. Mr. Chairman, the docket is in order.
Thank you. We'll take before we take appearances, though, I want to make sure everybody, when you talk, either get to a podium anytime you talk and get to these microphones, because we have a hard time with the live stream and hard time hearing you. So want to make sure everybody gets heard and seen. So you might not care about all those people out there, but I do. So anyhow, we'll start on the left. We'll start over here with Mr. Burgess.
Good morning, Mr. Chairman, members of the Commission. My name is Chad Burgess, and I represent Dominion Energy, South Carolina.
Good morning, Commissioners. My name is Heather Shirley Smith, and I'm representing Duke Energy Carolinas as well as Duke Energy Progress.
Mr. Chairman, members of the Commission, I'm Richard Witt. I'm from Austin Rogers, and I'm here representing the South Carolina Solar Business Alliance.
Mr. Chairman, members of the Commission, Jamie Golden on behalf of Johnson Development Associates Incorporated from the law firm of Nelson Mullins.
Good morning, Mr. Chairman. Weston Adams with Nelson Mullins. I'm here for Johnson Development.
Good morning, Mr. Chairman. Jeff Nelson and Andrew Bateman for the Office of Regulatory Staff.
Good morning, Mr. Chairman, members of the Commission. Plan Holman with Southern Environmental Law Center representing the Coastal Conservation League, Southern Alliance for Clean Energy, and with me, my colleague Stinson Ferguson.
Okay, thank you. See, if you get up, and everybody has to have a little line, get up and walk a little bit. It keeps you sharp and keeps your legs from going to sleep. So I think y'all have, everybody has talked with Mr. Stark about procedure here. And as I understand it, we're going with the joint petitioners are going to go first. And you've signed up for a certain number of, a little bit of time. So where I have it is Mr. Witt.
Thank you, Mr. Chairman, members of the Commission. As I stated earlier, Richard Witt from Austin Rogers. Mr. Chairman, members of the Commission, we're here today to argue for consolidation of these dockets where it makes sense. We believe that that consolidation will lead to conservation of ORS, the other parties, and this Commission's judicial economy. And it'll also lead to consistent rulings across these important issues, these threshold issues. Mr. Chairman, members of the Commission, I want to just simply publish without comment some of the commonality issues between these dockets. And I'm going to read these to you because it's going to show you the breadth of commonality among these dockets. And later, Council will discuss some of these in more detail. But under avoided costs, we have solar production and performance treatment. We've got ancillary services treatment. We've got integration charges. We have peak and off-peak hours and seasonality. We have energy storage treatment, natural gas forecasting, load forecasting, and wholesale market purchases. And all those issues will be common between these dockets, in our opinion. One of the issues that will come up is standard offer, and the commonality among the dockets will be the size and the tenor or length of these agreements. And there's also prohibitions of what this Commission should do that are going to apply across the various dockets. Form contract power purchase agreements. There's threshold issues such as force majeure, indemnification, choice of venue, confidentiality, and there's also prohibitions that will be common. Commitment to sell forms. An issue, and that is going to be LEO formation and requirements. And also, an issue across the dockets will be a LEO standard. We understand that DEC, DEP, and Dominion will all as part of their future filings, will offer a LEO standard. A LEO standard is very important to the South Carolina Solar Business Alliance and its members. And it would be very problematic if we had different standards or different issues across two dockets. If it's considered as a commonality, then there'll be less of a chance of that. Also, as far as contract links, it'll be common that there's going to be minimum PPA terms of 10 years, and in certain circumstances, they'll exceed 10 years. We're really interested in consolidating, but if we don't consolidate, the entities that will be hurt on this will be my clients, the solar developers and other intervenors, and also ORS and other participants. If we don't consolidate these dockets, we'll have file testimony in numerous dockets. We'll have intervenor attorneys appearing in numerous dockets, and the expense that'll cause my clients and other intervenors. Also, in these interventions, we usually utilize pro hoc vici admissions, and that's completely unworkable across 16 dockets. The fees with the Supreme Court are $250, and also each one of these, as you all know, each one of these comes before this commission for a decision. So it takes up time. It's part of your judicial economy because you make a decision at your Wednesday business meetings on all of these interventions. Since the problems seem to fall mainly on the intervenors and ORS, that means that the problems don't accrue to the utilities. And one of the arguments that's been made is that it would be confusing to consolidate these dockets. Now, I had the privilege of appearing in front of this commission about, I guess last month, about 30 days ago. And in that, I brought up a case that everyone's familiar with, that's the South Carolina Supreme Court saying that this body sits as a panel of experts. So the South Carolina Solar Business Alliance would offer that since you sit as a recognized body of experts, a panel of experts, we don't think you'll be confused by consolidating these dockets where they're appropriate. And we of course, believe this commission is able to understand these issues. Separate dockets does undermine judicial economy, and we think that consolidation is the way to go. Now, we do have some information for you today. The South Carolina Solar Business Alliance concedes that our original request for a methodology hearing before the full proceedings began, that's no longer workable. And that's not anybody's fault in specific, but due to time constraints, we concede there's no longer time for that. However, we do think it's very important, and we still maintain that there's time to have a workshop, a technical conference, and or a pre-hearing conference so that you and your senior staff and your attorneys can be exposed to South Carolina Solar Business Alliance position on methodology and important issues. And you know, there's been some concern about whether we were maintaining that decisions would come out of those conferences. We don't take that position at all. We know that evidence comes through the witness stand and comes through this commission after it's properly noticed. We're talking about a chance for everyone to get together, including the utilities, to discuss methodology because it is a complex matter. We just see Act 62 as a complete reset on avoided cost. And, you know, this commission has been dealing with avoided costs for a long time, but now there's a reset on the methodology, and we think it's important that we get together to talk about that. I want to publish something that's from May the 29th. Chairman Randall, this was you early on when you were having a colloquy, I believe, with Commissioner Belser about opening these dockets, and, you know, it seemed to indicate you had to open the dockets and things, which is fine. But you stated that day a quote, which I'll publish. This is Chairman Randall. I certainly will entertain some conversation about that. I think we've decided on when we're opening dockets, we need to open a separate docket for each utility. But the important part, Mr. Chairman, as you then said, and then combine them if we can in places that make sense. So we appreciate you having that foresight, and we think this is a place where it's going to make sense, especially in avoided costs, because of the commonality issues that I've laid out for you. And as far as the authority of this commission to consolidate, there's no question that this commission has authority to manage this docket and to promote judicial economy and be heard as much as possible. But the interesting fact is that as you sit here today, Mr. Chairman, and members of the commission, both Dominion and Duke have been engaged this week in a proceeding in North Carolina on avoided costs that was consolidated. So it's not an alien thing, something they're not used to, something they can't deal with, or something that doesn't make sense. As you sit here today and earlier this week, they've been participating in such a docket. Mr. Chairman, members of the commission, I appreciate time to appear in front of you.
Thank you.
Thank you.
Mr. Golden.
Mr. Chairman, members of the commission, we are here at a very important juncture in this proceeding. Counsel for the SBA alluded to the fact that time is ticking. We're a third of the way done with the 6-month requirement that legislature sent over here to get these orders issued. And that's through no one's fault. I'm not blaming y'all, I'm not blaming us, and I'm certainly not blaming them. That's a third of the way done, and I think we all recognize that. For that reason, right off the bat, I want to disarm them and take away a little bit of their argument and give them something. Our schedule that we have proposed is not workable on having a hearing to set a sole methodology for this state. We just can't do it in this time frame. It's in y'all's discretion if you want to have a sole methodology. It's in y'all's discretion to approve their methodology, but we are not able at this point with 4 months remaining to have that full-blown hearing on methodology. And again, I think now what we have to do to satisfy the act is consolidate to get this thing done in the next 4 months. We filed a petition almost a month to the date ago to set this, and we're here. And we're ready to consolidate, and we're ready to move forward. I do think there is value in what Mr. Witt said, that a technical workshop or a forum, I think Commissioner Hamilton in the previous business meeting, you alluded to the fact you had not heard from the utilities. They hadn't had an allowable ex parte. They had not come before you. Let's have a forum where you're tired of hearing from us. Let's bring our experts in. Let's bring the resource planners in. Let's have that. Don't take any formal action, but let's get these guidelines that 584120 requires before you all so that we can figure out how to get the rate and the term of length. There's two things that make this act, and it's the tenor of the contract and it's that avoided cost rate. Consolidation, as I've said, is paramount. Compressed timeline, I can't concede that enough. But what I can say is that conservation of resources is probably the strongest argument for consolidation. The burden is on all of us, is on the ORS, is on the other interveners, not on the utilities if you do not consolidate. Commissioner Irvin, you've looked for other states and jurisdictions to see what they do. Literally, as we're standing here talking, both of those utilities are going through this consolidated process in North Carolina, in Raleigh today. Why not here? Also, from a cost perspective, who bears the cost of having 3 or even 2 proceedings? We do, the ORS does, and ultimately the ratepayers do, because they can ask for that to be rate recovered. For those reasons, consolidation is consistent with Act 62. The utilities concede that the compressed timeline was unworkable for our schedule. So they're in agreement. You're not going to hear that there's, not a compressed timeline. What you are going to hear is why there shouldn't be consolidation. And for the life of me, I can't figure out why. There are commonality of issues. Commonality of issues exist. The only result that should be different is what that rate is for each of those utilities. Every other item that Mr. Witt hit on is utility wide is statewide. It's not utility specific. I've shown a chart that I'd like to proffer as Exhibit 1, where I've listed some items. I've given it to council before proceeding. I don't assume they have any objections with our list. May I?
Yes. Right, that's good. We'll put it on the Elmo, that way everybody can see it.
Those watching at home and those in the audience, we can see these are the issues in this proceeding. They all are common to the South Carolina. They are not utility specific. The only difference is the numbers that you put in there and possibly what the number is that you get out of there. I want to talk a little bit about tenor of contract. At the General Assembly, that was probably the most contentious issue, this 10-year, 25-year PPA term. You know, my client made no secret. We went in and wanted 25 years as a state policy for PPA terms. The utilities came out and said, 10 years is the maximum. General Assembly, as you can see in Act 62, has set the floor at 10 years. And then with certain parameters, you can argue for a longer term contract. Well, that was never utility specific. Not a single point of testimony was taken where that was set to be utility specific. That was South Carolina policy that was being determined. Commission, they gave y'all the wisdom to make that determination, not for each utility, but across the board. Commonality of issue, you know, it's a potential for y'all to prohibit integration charges. Why would that be utility specific? That doesn't really make sense. Certain threshold issues such as force majeure, confidentiality, standard offer, forms of commitment, those are all state policy issues, not utility specific. There should be commonality. So I just don't see why we would not accommodate judicial economy by consolidating. Again, you've heard that a LEO standard is for the first time going to be formed as a South Carolina LEO standard. The state will implement a South Carolina LEO standard. Counsel for both Duke and Dominion have represented to us that they intend to file their LEO standard with their proposed filings in these proceedings. Why would we want inconsistent LEO standards for each utility? That, again, that's bad policy. That's bad for everybody. It would actually be bad for them operating multiple systems. Again, I alluded to the fact that North Carolina consolidated, never heard anybody complain about it. Don't know why we would differ from that. You know, the legislature has deferred to y'all a lot on this, and we're here to say, you're right, it says a docket. You know, the plain language says a docket, but we're not making an argument that you can't open multiple dockets. I'm not, you know, in good conscience, I can't say that, okay? But what I can say is that you can consolidate where appropriate. And consolidation is going to be the best avenue to get a just and fair result in the next 4 months so that we don't end up back at the General Assembly saying, look at our result, and them being displeased with that. The General Assembly's watching, the state's watching. We've got to consolidate and get these things going where we can. In closing, I want to thank all of you for your attention to this time, setting this for a hearing. I don't think there was any other way to get it, you know, to get this decided, and I appreciate your time.
Thank you. Mr. Holman.
you. Mr. Chairman, I will be brief. I think as a grizzled veteran of avoided cost dockets, I would commend an approach to you. You've been given a very tight timeline. You've been given a hard task. But it's clear the General Assembly wants a new approach. Otherwise, there wouldn't be an avoided cost provision here. And they've given you a tight timeline. They've given you a lot of new things to consider. They've asked you to open a docket. All of these, to me, support consolidation for the efficiencies of the hearing, the parties like our parties who have to intervene. Much easier to do it in a consolidated docket. I think it'd be easier for staff to identify which issues are cross-cutting. Because some of the issues are common across the utilities, and I think even Dominion in their filing said many of the issues are unique to the utility. That's what they are asserting. Well, that means that some, not all of them are. Some issues are common, and we've, I think, agreed that a lot of these issues are common and should be dealt with in a uniform way, because the point of this bill, as I've experienced it and read it, you know, in section 584105, it directs that the PSC should look at rates and rate design to properly reflect changes in the industry as a whole. Because what we're undergoing now is a sea change in how power is produced in the United States. And I think the General Assembly recognized that and is looking to facilitate an orderly deployment of solar, recognizing that solar has common interests across the state, and in the avoided costs purple world, these cross-cut in different utilities. And the way to deal with that cross-cutting, those issues, and have the what uniformity you can achieve is through a consolidated docket. Thank you.
Thank you. Commissioners, any questions of any of these folks? Commissioner Irvin.
You alluded to the fact that the utilities as parties have been in a consolidated docket in North Carolina. Is that before their Public Service Commission, the equivalent of?
That's my
I know
understanding.
it goes under another name, but.
PUC.
Yeah.
That's my understanding.
Right.
We're not a party to that, but that is my understanding.
Okay. Have any of the attorneys been a party to that proceeding? You followed it with any interest?
My firm is a party. I've not been involved there.
We need to get you at the microphone.
Lauren Bowen, who is my colleague who's been before you, is up in North Carolina right now in that proceeding, but I will confess that I'm not familiar with it myself.
Is the order online that consolidated that docket, or do you have a copy of the order that did so? Okay.
We can get it. This is not the first. They've been doing it for
A number of years.
at least 5 years,
Right.
Since 2014.
Okay. Thank you.
Thanks. Any other commissioner questions? Commissioner Belser.
Mr. Golden, since you're standing there, we'll start with you, but if any of the other attorneys want to chime in on this, they're welcome to do so. If there is a consolidation of the dockets for purposes of hearing and a general methodology, can you envision that there could be some differences for a methodology for one utility versus there could be some tweaks, that something that might need to be in the methodology assigned to one utility but might not be applicable to another utility?
And I do. I think that is part of it, but I think it's de minimis. I don't think it's anything as far as those tweaks. The formulas used, and again, we're not even asking for them to be bound to a sole methodology. They can use Peaker, they can use DRR, they can use proxy. Whichever one that they want to file, they can use that serves them. But as far as those numbers and the inputs and what values they give, show us the work. That's what this encourages. Act 62, I wouldn't be here today if the General Assembly said the status quo isn't working, okay? And they want us to be able to see transparency. We want to be able to see in a consolidated hearing what those are. And if those numbers are different and there's a valid reason why, I don't think consolidation harms that.
I'm not even talking about the numbers. I'm just talking about the inputs in the methodologies. Would you agree that Act 62 does give the commission latitude to approve more than one methodology?
I would, absolutely.
I threw that out. If anybody else wants to add anything, you're welcome to.
Richard Witt from Austin Rogers for South Carolina Solar Bid Plants. I just think it's important that we agree with what Mr. Golden's answered, that that's certainly correct. And we're not talking about consolidation of the umbrella of avoided cost. We went through and mentioned specific portions of it that would apply. Certainly they're going to have different inputs and maybe have different tweaks to it. But there's commonality, and that's what we're arguing for consolidation for.
Thank you, Mr. Chairman.
Thank you. Commissioners, any other questions? Okay, what we're going to do, I know we're going to go to utilities, and Mr. Burgess, you going first. We're going to, after the utilities, then we're going to take a short break, and then we're going to have time for a response from each group, the movements and the respondents. So.
May it please the commission, good morning again. My name is Chad Burgess, and I represent Dominion Energy South Carolina in this proceeding. And I want to start off by talking about docket number 2019-176E, and that's the docket that the chief clerk initiated on May the 23rd. And we understand why she did that. She's been clear with this commission. She did that from an expeditious point of view. She looked at the statute and recognized that this commission was on a short time frame within which to make the rulings that are required under the Act. So she opened that docket. On June 17th, Dominion filed a letter with this commission asking that docket be closed. And I want to reiterate that request again today, that it's our position that docket should be closed, and I'll explain the reasons for that. In the Act, it clearly says that the commission shall open a docket for each utility. It doesn't say that the chief clerk will open a docket for each utility. It doesn't say the utility will initiate a filing to open a docket. It says the commission shall open a docket. And on May the 29th, the commission staff and the chief clerk appeared before you, and they presented the law to you. They showed you a PowerPoint. They explained to you how the statute worked. And the chief clerk specifically said, it's your decision, not hers, as to how you wish to proceed. And at that meeting on May the 29th, Commissioner Belzer presented a motion to this commission and which this commission unanimously passed, which stated that the chief clerk shall open a separate docket for each electrical utility regarding the requirements thereof, speaking of the statute. You followed the letter of the law. The law clearly says each utility gets their own docket. You interpreted the law correctly, you followed it correctly, you applied it correctly. And we would submit that you got it right on May the 29th, and we would submit that you should not retreat from that decision that you made on May the 29th. It was right then and it's right today. The statute, and I've highlighted the operable language there for you, the statute clearly says that the commission is to open a docket for each utility. I don't know how the General Assembly could get any clearer with respect to what its instructions were to this commission, and you followed those instructions perfectly. The General Assembly understood and knows that there is more than one utility in South Carolina. That's why they use the word each. And each means when you have two or more of one thing, you treat them individually. You treat them on a one-by-one basis. If the General Assembly wanted you to commingle the dockets, they would have instructed you to open a single generic docket. They didn't do that. They used the word each, and each appears in this particular statute 8 separate times. So I don't know how the General Assembly could be any clearer with the commission with respect on how to open the dockets for the utilities. And your ruling clearly shows that you understood that. The chief clerk advised you as to how the statute read, and you applied it correctly, and you ruled correctly. Unfortunately, JDA and the SBA have seized upon docket 176E in order to advance a tortured interpretation of the statute where they argue consolidation. When you look at the statute, and I'll begin by saying that they don't like your decision. They don't like the fact that you got it right. They think you should consolidate the dockets. I've looked at.
I'm going to object. That's a gratuitous comment.
Mr. Chairman, the fact that they filed a motion disagreeing with your decision in and of itself demonstrates they don't like the decision that you've rendered in this docket.
Mr. Chairman and members of the commission, I agree. At no point have we said that you couldn't open these dockets and that they should all be consolidated and done away with. We, Mr. Golden and myself both listed issues of commonality which are important between the dockets, not that you can't have docket-specific decisions. And we've asked to consolidate the commonality of the issues, not that you consolidate the dockets and ignore what the General Assembly said. Thank you.
Mr. Chairman, with all due respect, I think they absolutely are ignoring what the General Assembly says. You will not find the word consolidation one time in Act 62. And they're encouraging you to act in a contrary manner. And I'm simply arguing the position you have followed the law correctly, and we encourage you to continue following the law correctly.
Okay. All right.
But Mr. Chairman, I'll move on from that.
Let's do less characterization of what the other parties are saying.
Fair enough.
Wait, I've got a question from Commissioner Belcher.
I'm sorry to interrupt, but given your last statement, Mr. Burgess, are you arguing that, let's just hypothetically say, we've got 3 dockets. Are you saying that the General Assembly has precluded the commission from consolidating dockets where judicial economy or other interests may necessitate that?
Judicial economy is not the standard that you follow when deciding to implement a statute. The statute drives...
about consolidating dockets for purposes of hearing. Are you saying that we're precluded from that?
I'm saying in this particular instance, you are precluded from consolidating the dockets, and I'm going to get to that argument here in a second.
Thank you.
Judicial economy is not the standard by which this commission decides whether to consolidate or not. The whether to consolidate or not is driven by the language in the statute, and the language is appearing before you. Each utility gets its own docket. So by the operative terms of the statute, you cannot consolidate these matters. Now, with respect to consolidation, what they would have you do, you've already opened 3 dockets. The clerk has already opened 3 dockets consistent with your order. They want you to consolidate the parties and bifurcate issues. That's the precise opposite of what the statute says. The statute says that the parties will be bifurcated, thus the word each, and the issues will be consolidated in each one of those dockets. When you look at the issues that are to be decided, standard offer, the LEO, the commitment to sell form, the PPA, the avoided cost methodology, and any other term that this commission deems necessary to implement the law, that's what gets decided collectively in each docket assigned to the utility. The statute uses the word and. That is conjunctive. That means you have to do 1, 2, 3, 4, and 5, not 1, 2, 3, and then separate 4 or 5 from the herd and address them in another docket. So, Mr. Chairman, lastly, I do want to just talk about judicial economy again. And judicial economy is actually not served here by not following the statute. The General Assembly has not allowed you to consolidate these dockets. Again, the word each means when you have 2 or more, you consider them separately. You've recognized that already. You've made a ruling on May the 29th, and you've instructed the clerk to open separate dockets with respect to that. And we would encourage you to stay the course with regard to that. Lastly, Mr. Chairman and members of the commission, judicial economy, there are 3 dockets that are existing right now. They want to create a 4th docket. 4 is greater than 3. That cannot be economical on its face. They want to have a separate matter to deal with the issues that they want to raise for you outside of the dockets that you have already instructed the clerk to establish for each utility, and we believe that should be rejected. So in conclusion, Mr. Chairman, Mrs. Commission, we urge you to reject the interpretation of the statute that they've advanced in the form of their motion to consolidate and deny their motion. We ask that you grant the request of Dominion Energy to close docket 176-E forever and proceed with the 3 separate dockets that you've already established. And lastly, we ask that you issue a scheduling order that is consistent with the scheduling order that the Dominion presented to the PSC Advisory Committee on June the 14th. That scheduling order that we've submitted, it did not include comments, technical conference, supplemental comments, follow-up comments, hearing. We followed the Commission's standard 421 policy, which is direct testimony, followed by rebuttal testimony, concluded with rebuttal testimony in a hearing. That procedure has been tried and true for many years from which this Commission has operated. It has worked in the past extremely well, and we believe it will work extremely well again. Thank you, Mr. Chairman. That's all I have.
Thank you. Mr. Smith.
May it please the Commission, again, I'm Heather Shirley Smith on behalf of the Duke Utilities. I'd like to thank the parties for withdrawing their request for a separate proceeding on avoided cost methodology. I would also like to thank them because that cuts down my argument by about half. We not only think that that approach was unworkable from a timing perspective, we believe it was deficient under the Administrative Procedures Act, and I will save y'all that legal argument since I no longer have to make it. But I would note that any party who wants to come before this commission and explain its thoughts on this process is permitted to do so within the limits of the allowable ex parte proceedings. Certainly, Johnson Development has done that. The companies have not come back before this commission because we were unsure when this oral argument might be scheduled, if it was to be scheduled, and we did not want to bind the commission's hands in terms of the 20-day rule. So, the companies are free to come forward with an ex parte proceeding to explain its methodology and inform the commission of its thoughts. So is any other party in the proceeding within the limits of those ex parte parameters. I will note that if we hadn't been spending so much of our time filing about methodologies and how it would be impermissible under the law to bifurcate those, we perhaps could have come up with a collaborative workshop schedule. Certainly the company would have been happy to talk about that, but we were not willing to have a technical workshop in lieu of a hearing. But we are where we are in terms of time. And so the issue before us, the issue before the commission is consolidation of these dockets. So the company has also requested that the generic docket, the general docket, be closed, and we maintain that request. For the interest of time, I subscribe to the arguments made regarding what the statute says provided by Dominion. The statute is very clear that each utility gets their own docket. I'd also like to point out the commonality of issues and proceedings document that was raised earlier. When I look at this list of items, it occurs to me that all of these things are utility specific. Solar production and performance treatment, that depends on a utility system, utility specific. Ancillary services treatment, depends on what ancillary services you have to the degree that you have them. I'm not even 100% sure what that is because you need to hear from technical experts from each utility to provide what that means to the utility. Again, utility specific. Peak and off-peak hours and seasonality, that's definitely utility specific. So to the degree to which you consider all of these factors, you do need to consider it, we believe, under the statute and as a matter of practicality, because each utility system is different. There are even differences in between the Duke systems. So we believe that it is important to maintain a docket for each utility. And again, believe that consolidation of all of these dockets is inappropriate. and also not called for by the law. We also agree with Counsel for Dominion that statutory interpretation doesn't allow the Commission to go there. Judicial economy is not a standard in statutory interpretation. And if the words are clear and unambiguous, then the Commission does not need to go to statutory construction arguments, nor does the Commission need to entertain legislative intent. And the theory behind that is because the words are clear. They mean what they mean. And I would point the Commission, to even the cases cited by JDA stand for that premise. Finally, we also believe that one thing has not been discussed here today, and that is customers. And so these rates are very different than rate cases that come before this Commission, where this Commission considers a utility's cost of service, whether the utility is incurring cost reasonably, et cetera. These aren't base rate case issues. These are pass-through costs. These are contracts governed by PURPA, influenced, of course, by the Federal Energy Regulatory Commission regulations and this state's implementation of PURPA. Once we incur them, those costs automatically accrue to customers, are automatically charged to customers through the fuel statute. So the decisions that this Commission makes for each utility on methodology and inputs directly affects how high or how low those rates are. And so we believe, again, those are utility specific, and those rates are in place for the term of the contract. And we believe the appropriate weight for this Commission to give all of those hefty considerations are through an individual docket. Finally, we haven't had a notice of intervention. We haven't had a timeline for intervention. And so it's unclear what other customer groups will come forward. But I will note that the only customer in this matter, the single party that filed comments who actually pays the rates that are charged, that will be coming out of this proceeding, has asked for individual dockets. We've heard a lot about judicial economy for the developers, and I don't know that there's a lot of judicial economy for customers to participate in a three-party proceeding when they are served by a single utility. So I believe that customers should also play a factor in the Commission's decision. And for those reasons, we ask for the Commission to to close the generic docket.
Thank you. And all right, we'll go to Commissioner questions, so we need y'all to be close to a microphone anyway. Commissioner Whitfield.
Thank you, Mr. Chairman. My question is actually for Ms. Smith and Mr. Burgess. Ms. Smith, you made your argument, of course, for the individual nature of each territory, of each electrical investor-owned utility in the state, and you talked about a lot of things from ancillary services to the different types of customers, territories, everything. But and the same question can go to you, Mr. Burgess, without getting back into the judicial economy argument again that you just talked to. Mr. Golden made a statement about 2 months have elapsed, and the meter's ticking on us, on this Commission, to carry out this new law. Again, without getting back to the judicial economy, how do you address Mr. Golden's statement about there not being enough time to do individual dockets?
All right, Heather, I'll take that first. The answer to that question is very simple. Take a look at the schedule that Dominion proposed. 421, like I mentioned earlier, our testimony deadline under that schedule is not due until August the 29th. It gives 4 weeks for the other parties to draft their testimony. There's no mystery as to what Dominion Energy is going to say in that docket, and that's because we've already said what we're going to say in our fuel docket. And you may recall that the Solar Business Alliance asked this Commission to bifurcate that proceeding in our fuel docket and remove avoided cost, remove the methodology. So we did that at your ordering. So they have in their file the testimony that we're going to file in the avoided cost docket upcoming. They know the methodology that we're going to use. The only thing that we're going to do differently is we're going to update numbers that need to be updated due to the passage of time from the fuel docket. So there is plenty of time, if you follow the schedule that we presented, to get all the work done that needs to be done and have this commission issue an order in a timely manner as required under the statute.
Mr. Burgess, I'm aware you've done that, and I don't have it in front of me, but with all due respect, we do have other companies and other territories in this state too that are going to have, you know, perhaps a different schedule, and a lot, you know, that a lot would have to occur between now and then to comply. So I would.
Yes, certainly. This commission, you know your business better than I do. You have multiple utilities, wastewater, water, electric, gas that you supervise on a regular basis, and it's not uncommon to have parallel dockets proceed on the same timeline. Y'all have managed that well in the past, and I don't see any reason why this commission couldn't do it again.
Thank you. If I could hear from Ms. Smith.
Similarly, the companies believe that there is enough time, and the notion of judicial economy being served by a consolidated docket, I don't think applies just factually. There's nothing about a consolidated docket that would lessen the amount of Duke Energy Carolinas or Duke Energy Progress witnesses, and I suspect the same for Dominion. There's nothing about a consolidated docket that would reduce the number of testimonies filed or responsive documents, discovery, et cetera. And there's nothing about a consolidated docket that would alleviate any burden on any individual customer that wants to participate in their serving utilities proceeding. Moreover, having a consolidated docket, especially at this juncture when there is so much to do and so much ground to be covered, does not serve the interest of a hopefully constructive resolution. So Duke Energy Carolinas or Duke Energy Progress may find an accord with interveners or customers or participants in its proceeding. So might Dominion. But how that would work in a consolidated docket, I don't know that we can work through that in the time frame allowed. Moreover, I don't think a consolidated docket would necessarily even shorten the hearings. To the degree that there are separate hearings and there are similar issues, I think it might make it more efficient. You know, certainly the last hearing might be quicker than the first. We've seen that, for example, in separate Duke rate cases that were filed concurrently. But for all of those reasons, we think there's enough time to do what needs to be done. I'd also note that Duke Energy has an avoided cost filing on file with the Commission. Now, certainly, we proposed and plan to conform that filing to any necessary changes required by the Act. But, you know, right now, we're working toward a August 14th filing as we proposed to conform that filing. And parties have had a pretty good visibility about what the company is thinking and what its theories are in that docket that's been pending for quite a while. So for those reasons, we believe the Commission would be better off adopting the procedural schedule the company proposed.
Thank you, Ms. Smith. Mr. Chairman, that's all I have, but at some point, I guess, I'd like to hear a rebuttal at some point.
We're going to have a chance for that. Any other questions, Commissioners? Commissioner Urban?
Ms. Smith, there was some talk or speculation that perhaps Duke Energy Progress and Duke Energy Carolinas could consolidate their hearings, but as I understand your argument, since these issues are all utilities specific, that really wouldn't work either, would it?
We think that there's some room to consolidate, certainly maybe the procedural schedule. But that gets further compounded if you add Dominion in the mix. I mean, certainly the company has some theories that would be consistent between the utilities, but the application to the system would be different.
So if you had an expert, for example, on a given methodology, that expert wouldn't have to be called twice necessarily.
I think it would depend upon what the parties in that case want, right. But certainly there could be cross from one docket. There could be cross from a Duke Energy Carolinas docket that the parties could agree to import for Duke Energy Progress. We saw that in the recent rate cases, and so that's the type of activity that could serve judicial economy, but not having one docket instead of two.
So bottom line is you would prefer to keep them as separate dockets?
Yes, sir.
Thank you.
Commissioners, any other questions? Okay.
Mr. Chairman, if I might, ORS does not take a position on this. I just wanted to be clear based on some of the comments that were made earlier today already that we do not object to consolidation. We don't object to individual dockets either. We believe that we have checked with our experts that we intend to use in these dockets. They have said that they are available. We have no objection to the commission deciding one way or the other based on what it believes is proper in this case to either do individual dockets or do a consolidated docket. Thank you.
Thank you, Mr. Nelson. Okay, we're going to take a short break, and then we'll have response from both parties again, and before we finish. So, about 10 minutes, yeah. Okay, so we will go to response. I know we've, with Mr. Stark, talked with you, the joint petitioners and the respondents have all each agreed to a 5-minute response. So we'll turn it over to you, Mr. Witt. Make sure you're on over there.
Thank you,
Those are
Mr.
supposed
Chairman,
to be
members of the
back.
commission. I'm Richard Witt from Austin Rogers, once again for the South Carolina Solar Business Alliance. We appreciate the chance for this brief response. With all due respect to counsel for Dominion, he said a couple things that we'd like to clarify. I think that he said, subject to check, that we were looking for a technical conference instead of a hearing. And I don't believe that's the SBA's position, and it hasn't been. And I think I alluded to in my argument the fact that we realize a technical conference wouldn't be a place to take evidence. So just, we don't want you to be misled by that. Also, I think that counsel said that he didn't think there should be a technical workshop and there shouldn't be these preliminary matters that SBA's asked about. One of the things he said that he didn't think we should have is a pre-hearing briefing or conference. So that's in the rules. So I don't think that Dominion can take that away, because I think that's certainly available in, we don't do it in every hearing, but it's available in the rules. Another thing is any discussion about customers. The South Carolina Solar Business Alliance's members all have customers that are all paying these rates and all affected by it. And we also, talking about customers, the South Carolina General Assembly has indicated that they want to have a focus on solar and that it would be good for South Carolina, and that's why it's called the Energy Freedom Act. So we think that customers are certainly being covered by the South Carolina Solar Business Alliance. We didn't hear anything about North Carolina having a proceeding that this worked just fine in. I didn't hear anything about it. So we think that it makes sense for consolidation, but we're not saying, and haven't argued, that there shouldn't be dockets for the individual utilities for the final computation of avoided costs. We've argued, and also JDA Associates and SBA have argued, that we're talking about issues of commonality that could be handled in docket 2019-176E. We certainly think that's appropriate, that should be left open. And Commissioner Irvin, you asked a question about, would this cause duplication for witnesses and experts? Of course it will. There's no way to get around that. If we've got different dockets where, you know, all of you know we're going to be filing pre-file testimony, and SBA is going to be having experts for every docket. And another thing I didn't hear a whole lot of response to was the fact that when we have all these common issues in different dockets, the problem that we could end up with inconsistent decisions and rulings, which would cause the staff to come back before you again. So when you're setting up a LEO standard for the first time in South Carolina, we're going to do that in 2 different dockets. And we also disagree that there's anything that precludes this, as Commissioner Belser alluded to, there's nothing to preclude this commission from managing this docket. And that's always been your prerogative. And we think you have plenty of latitude to handle the consolidation. And we're not saying handle consolidation in some sort of bizarre way. We're saying in a reasonable way, leaving the issues that should be unique handle, but the commonality should be handled in 176E, and we should move forward. But we didn't say close these other individual dockets. And I still go back to my comment from the chairman back in May. From the start, you recognize that there should be a combination of some of these issues where appropriate. But in conclusion, we appreciate the opportunity to appear, and clearly there should be a consolidation of these issues where they're common. Thank you.
Thank you.
Chairman, I grew up in church, and the preacher would always put his watch on there, and I know
Yeah,
turn it back.
you noticed me doing that.
I did, so I'm going to put it back 5 minutes for you, if that's. No, I'll be very brief. The status quo is not why we're here. That General Assembly did not pass a bill 110 to nothing on the House side and 46 to nothing on the Senate side for Dominion to come in and file what they filed already this year, for Duke to come in and file what they previous filed. That's clear. There is absolutely no ambiguity. This is post-Act 62 world, and and we're living in it. Two charges in that legislation: promote renewable development, protect the ratepayers. Consolidation does both of those, and I'd be extremely impressed to hear how that doesn't happen. We're all customers. Johnson Development's a multi-division corporation in Spartanburg, South Carolina. To say that they're not ratepayers, the only ratepayers you've heard from, again, I disagree with that. Finally, Chad did a good job of using the word each. I think he said that each was in the bill entire eight times. Well, if you look in the first sentence of 584120, it says a docket, not dockets. I've drafted legislation for a living. If I wanted to put dockets in there, I would have. We brought this act to the General Assembly. We brought it here, and we believe that consolidation is the proper avenue. Thank you.
Thank you. Okay, Commissioners, any questions? Commissioner Belzer?
Thank you, Mr. Chairman. Mr. Witt, I just wanted to ask, you mentioned that in a case in North Carolina where consolidation works, and what case were you referring to?
Well, I'm talking about the fact, first, Richard Witt from Austin Rogers for South Carolina Solar Business Alliance. I'm talking about the ongoing, started Monday of this week, avoided cost hearing, which is consolidated for Dominion and Duke. And we, both of us alluded to that. And when they got up, I didn't hear them say, well, this is a nightmare in North Carolina.
I just wanted to know if that was the same one that had been referenced earlier, or if there was a different one. Thank you very much.
No, thank you.
Thank you. Commissioners, any other questions? Okay.
May it please the Commission, again, Chad Burgess for Dominion Energy. The statute clearly doesn't allow for consolidation. It's crystal clear. The legislature has given you direction on how to treat these dockets. You have issued a ruling on May the 29th. You issued your order correctly. You found the statute to require one docket for one utility. With all due respect to Mr. Golden, the statute doesn't stop at the word docket. You have to keep on reading it to understand the full context of it. And if you stopped at a docket, then you may be right, but you don't. You keep reading till you get to the word each. And I've explained to the Commission that each means when you have two or more, you consider them individually, which is what you've already recognized to do. With respect to your comment, Mr. Chairman, Mr. Witt, I didn't check the record on that, but I have no reason to believe he's not correct. I wrote down, if we can. You just said that top of mind, if we can. You cannot. Unfortunately, the statute drives what you're required to do here. With respect to consolidation, if you did consolidate these dockets, you would have 3 mini trials in one proceeding. That in and of itself flies in the face of judicial economy. There will be confusion among customers as to avoided cost methodologies, and we do not think that's proper in order to do that. That's why the General Assembly said one docket for one utility, stay in your swim lane, and get the order issued by November, which you're on track to do if you follow the procedural schedule order that we've submitted to you. Lastly, I want to mention before I do that, one thing Mr. Witt said, I didn't say anything about pre-hearing conferences. I've never said anything about that. Your rules are crystal clear on that. You can have pre-hearing conferences. I've never said you couldn't have that. Lastly, the North Carolina docket. I don't know what the North Carolina law says, and quite frankly, it doesn't matter because the General Assembly has passed a law for South Carolina. That's what matters. That's what we're here to follow, and this commission has followed that law correctly. Again, the word consolidation does not appear in Act 62. The word each does multiple times. Each utility gets its own docket. Thank you, Mr. Chairman.
Thank you. Commissioners, any questions for Mr. Burgess? Okay, I appreciate everybody being here. We thank you for what?
I have a question for Mr. Burgess. I have a question for Ms. Smith, please.
Okay.
Sorry. Ms. Smith. Sorry. Not Mr. Burgess. Sorry. I was looking at the letter from Duke on June the 20th, where y'all set forth the identical procedural schedule. Under that procedural schedule, are you maintaining that there would be one hearing for the Duke companies or one hearing for DEC and one for DEP?
We believe that we can work through that. So what we don't want is to have, and what we don't think would be appropriate is to have a hearing with Dominion. But we do think we can achieve some judicial economy for Duke Energy Carolinas and Duke Energy Progress noticed at the same time, or either, certain days within the week, and achieve economy through perhaps external witnesses. For example, if ORS's witness wanted to appear once, then that might make sense to work through that. And that's exactly the kind of thing we could work through in a pre-hearing conference.
Okay. But there could be one proceeding, but at some point there might be a divergence where you're talking DEC and then a divergence talking DEP.
Correct, but it would be two dockets separately noticed,
Right.
et cetera, I guess.
Okay, thank you very much.
Thank you. Any other questions, commissioners? Okay. Thank you all for being here today. We appreciate everybody's comments, and we are adjourned.